Chapter 3, Examination of Formal Requirements. Welcome to your Euro Patent Brief Journey, with Baris. We're about to dive into the intricacies of the title of your invention and other formal requirements for your European patent application. We will follow the content of the EPO Examination Guidelines. This can be a complex topic, but don't worry, I'm here to guide you through every detail. Let's tackle this together, step by step. 7. Title of the invention. 7.1. Requirements. The request for grant must contain the title of your invention. This is not just a formality. It's an essential part of your application. According to Rule 41(2)(b), the title must clearly and concisely state the technical designation of the invention. It must exclude all fancy names. Let's break down what this means. Roman 1. No personal or fancy names. Personal names, fancy names, or terms like patent that are non-technical and do not serve to identify the invention should not be used. Roman 2. Avoid vague terms like etc. The abbreviation etc. is too vague. It should be replaced with a specific indication of what it is intended to cover. Roman 3. Avoid vague titles. Titles such as method, apparatus, or chemical compounds alone do not meet the requirement. The title must clearly state the technical designation of the invention. Roman 4. No trade names or trademarks. Trade names and trademarks should also not be used. The receiving section will intervene if the names used are commonly known to be trade names or trademarks. Pause here. Take a moment to reflect on your title. Is it clear, concise, and technically accurate? This is your chance to ensure your title meets the EPO requirements. 7.2. Responsibility. Now, let's talk about who is responsible for ensuring that the title of your invention complies with these requirements. The examining division bears the ultimate responsibility for ensuring that the title conforms to the provisions of the implementing regulations. However, the search division also plays a role. They will take action and amend the title if necessary, to avoid the publication of applications with non-compliant titles. In some cases, the EPO will change the title on its own initiative, if this appears necessary. When the search division approves the title, you will be informed upon the transmission of the European Search Report. The approved wording of the title, in the 3 official EPO languages, will be notified to you by the communication announcing the forthcoming publication. Remember, the title of the invention is published and entered in the European Patent Register in capital letters. Pause here, reflect on the importance of getting the title right. The title is not just a label, it's a crucial element that must accurately represent your invention. 8. Prohibited matter. 8.1. Morality or order public. Let's move on to the topic of prohibited matter. Your application must not contain statements or other matter that is contrary to order public or morality. Such matter may be omitted when the application is published. If this happens, the published application will indicate the place and number of words or drawings omitted. The receiving section may check the description, claims, and drawings to ensure they do not contain prohibited matter. To avoid delays in the formalities examination, this check will be cursory. It's meant to ensure that the application does not contain statements constituting an incitement to riot or acts contrary to order public, discriminatory propaganda, or criminal acts. Grossly obscene matter is also prohibited. If the search division finds such prohibited material, they will notify the receiving section. The applicant will be informed of the material omitted. Pause here, think about the content of your application. Does it comply with these standards? Ensuring that your application is free of prohibited matter is crucial to avoiding delays and complications. 8.2. Disparaging statements. According to Rule 48(1)(b), your application must not contain statements that disparage the products or processes of any particular person other than the applicant. This includes the merit or validity of applications or patents of any such person. However, mere comparisons with the prior art are not considered disparaging per se. If disparaging statements are found during the cursory examination, or if the search division draws attention to them, the receiving section may omit these statements when publishing the application. In cases of doubt, the matter is left for the examining division to decide. If any material is omitted, the published application must indicate the place and number of words omitted. The EPO will provide a copy of the omitted passage upon request. The applicant will be notified of any material omitted. Pause here and consider. Does your application include any statements that could be considered disparaging? Ensuring a respectful and objective tone is key to maintaining the integrity of your application. 9. Claims fee. Let's discuss the claims fee, which applies to European patent applications containing more than 15 claims. If your application contains more than 15 claims, at the time of filing, a claims fee is required for each claim in excess of 15. For applications filed on or after 1 April 2009, a higher fee is payable for each claim in excess of 50. The claims are counted in the order they were filed. If your application contains more than one set of claims, the claims fee only applies to the set with the highest number of claims. If claims are deleted due to non-payment of claims fees, and the number of remaining claims in the original set falls below another set, then the number of claims in the latter set must be reduced to match the number remaining in the original set. The claims fees must be paid within 1 month of filing the claims. The correct claims fee is calculated based on the set of claims first filed. Pause here and think about your claims. Are you clear on how many claims you have and what fees are required? This is your opportunity to ensure that all fees are paid on time. 10. Abstract. 10.1. General remarks. Every application for a patent must contain an abstract. This abstract is a brief summary that provides an overview of your invention. 10.2. Content of the abstract. While the responsibility for the definitive content of the abstract lies with the EPO, in practice, this task is delegated to the search division. The definitive content of the abstract must be determined and transmitted to the applicant, along with the search report. If the search division determines that the abstract filed does not relate to the claimed invention, the applicant will be informed and invited to correct the deficiency. Pause here, consider your abstract. Is it clear, concise, and does it accurately reflect your invention? This is your chance to make any necessary adjustments before the search report is issued. 10.3. Figure accompanying the abstract. If your application contains drawings, you should indicate which figure, or figures in exceptional cases, should accompany the abstract. If you do not meet this requirement, the search division will decide which figures to publish with the abstract. Pause here, reflect on your drawings. Have you indicated the figure that best represent your invention? Ensuring that the right figures accompany your abstract is crucial to effectively communicating your invention. 11. Designation of contracting states. 11.1. General remarks. All states party to the EPC, at the time of your application's filing, are automatically deemed designated in the request for grant of a European patent. If any other state is entered on the request for grant, it must be disregarded. When the application is in the name of joint applicants, each may designate different contracting states. However, objection will be raised during the examination of formal requirements if there is any ambiguity as to the states designated by the individual applicants. Pause here, consider the contracting states. Are all the relevant states correctly designated in your application? Ensuring that all designations are accurate and clear is vital to securing protection in the desired jurisdictions. 11.2. European patent applications filed on or after April 1, 2009. 11.2.1. Designation fee, time limits. For applications filed on or after 1 April 2009, a designation fee is payable for designating contracting states. This fee is a flat amount, covering all EPC contracting states. Therefore, the previous system of charging designation fees for individual states no longer applies. Pause here, ensure you're clear on the fee structure. Understanding the costs associated with designating contracting states is crucial to budgeting for your application. 11.2.2 Payment of designation fee. All states party to the EPC at the time of filing are automatically designated when the application is filed. However, the designation fee may be paid later, within the time limit specified. Payment of the designation fee covers all contracting states, except those for which the designation has been expressly withdrawn. Pause here, reflect on your application's coverage. Are all desired states properly designated and the fees paid? This step is crucial to ensuring that your application secures protection across all intended jurisdictions. Recap and reflection. Today we've covered the critical formal requirements of your patent application, including the title of the invention, prohibited matter, claims fees, the abstract, and the designation of contracting states. Take a moment to reflect on these procedures. In our next session, we'll delve deeper into other essential aspects of your application to ensure that every detail is in order. For now, take a deep breath and review today's material. You're making excellent progress. Keep up the great work. Remember, the key to mastering these details is consistent practice and review. Thank you for your continued dedication. See you in the next session.